Welcome everyone. This is week two, class two of the trust and contractual legal safeguard course. It is Saturday, May 17th, at 2:06 p.m. Eastern Standard Time. All right, so welcome everyone. Welcome. Everyone has been everyone's received week one and week two of the course guide study guide, and you'll be receiving week three at the end of next week. And so you'll also be receiving the recording tomorrow afternoon. Recording should be available. If it's sooner, I'll send it out sooner. But yes, I do have an event today. So, Brother King, we have here, and we see here, he did Trust and Contractual Legal Safeguard Course, Week 2, Sovereign Union of Moorish Tribes in conjunction with the Moroccan Post School of Government International Law. All right, go ahead, King.
Okay, so today, as you look at the course outline, I want to go over some functions. So you will understand how a trust, whatever you create, it has to behave a certain way. You must understand the terms in the contracts determine how your trust behave, how the trustees behave, how the beneficiaries receive benefits, how a trust protector. Some of y'all need a trust advisor. A lot of us don't have those makeups because what we was taught about trust was just a smidgen of understanding on how to create a situation that's more favorable and more conducive to a more probable outcome where you can have success. You don't set up a trust and you don't have particular experts or information at your fingertips. You must know how to utilize the instruments that you're trying to utilize to receive certain tax benefits, to protect your constitutional rights under that trust. You must understand all of the things, your status in relationship to the trust. You must understand all of these variations in order for you to be able to have a true understanding of your trust. So we're going to talk about a revocable living trust, aka created by a grantor during life. Grantor may amend or revoke at any time while competent. So let's talk about competency too. Because before I go to typical use and key and pros and cons, a lot of us get into situations where we feel like we're competent. A lot of us are in contracts with credit card companies, mortgage companies, government, and you're not really competent. So some of the things set up in a trust, if you have children, you should disable them to be able to be competent. This is why you have attorneys. Why? Why do you have attorneys? Because they're competent. They study law. This is why they say a person who is their own attorney has a fool for an attorney. Why do they say that? Most of us are not competent in the legal terms, understanding the legal structure, the legal system, and all the various components to be able to articulate a proper legal argument to have standing. So some of us may want to disable even yourself from getting to contracts. You might set up an institution that does all the legal work. This is why a lot of the rich families have law firms become their trustees in certain events to do what? Handle all their legal matters and make themselves indemnified due to the fact that the attorney or the law firm is going to handle all their legal affairs. I didn't say personal, I said legal. There's a difference. So I just want you guys to understand, a lot of you guys are been told to create a trust, but you're not even competent to even manage and safeguard your trust. This is why you might need other resources and other individuals involved. Because you do not have the wherewithal to execute and run a trust. You don't know the tax codes. You don't know there is 10,000 volumes. I didn't say codes, 10,000 volumes of the tax code itself. And each volume holds so many codes. You're talking about hundreds of thousands of codes. Most of your CPAs don't even know the tax code in totality. So you might have several tax accountants that specialize in different fields of accounting with the Internal Revenue Service. I need y'all to start, when we look at this with a magnifying glass so we can start understanding how to move when formulating a trust. So I want to go to now the typical use. Put on my glasses a little bit. It says in a revocable living trust, right? You avoid probate. Okay? So what has to happen when you have a living trust and a will? Most of you say, hey, I got a will and a living trust. You have to understand the living trust is now placed, the will is now placed in the living trust. It's placed in a living trust. It contracted it to do the probating of the estate, removing the probate court because this is now not a public venue, it's a private venue. Do everybody understand what I'm saying? So when you understand what you're doing, you understand the formalities. So you set up your living trust and you now take your will and now you contract for the living trust to execute your estate. And now you find an executor and then you take 3 different copies, put them with 3 individuals who will secure your estate. They sign off on it because that will is your estate. And if the reason why you're doing that is you safeguarding if someone pass away. If 2 of the individuals who were witness, right, pass away. Now you have at least one other person who can testify to the truthfulness of the content of your will. Do that make sense to everyone?
Can you have mentioned something? You mentioned about public and private, and can you elaborate on both?
For as what? The the will and the trust, I mean, living
You
trust.
mentioned public and private a few minutes ago, and I was trying to get in for you to, you had asked, does anyone understand what you,
Okay, when we talking about public and private, okay, when you do not have a will and you go to what they call intestation, the government gets involved. It gets involved because you left them no choice. You're a citizen, and that's what they do. They get involved. But when you handle your own personal affairs, government is considered public. I want you to understand. We're dealing with, when I say public and I say private, I'm talking about your own personal rights. When I say public, I want you to think of government and their personal rights. And your status, right, as it relates to yourself and government. What is your obligation to the government and what is the obligation to you? And what is your obligation to your own self and to your own family? What is your status in that? That will be revealed through your contractual relationships, through the trust, your will, and other institutions that you create. Some institutions you may be the beneficiary. Some institutions you may be the grantor. Some institutions you may even be a part of the board of trustees. But that's all about your understanding how to create a dynamic in which comes out favorable for you and your family. Did I make sense of that, Abdullah, when public and private? Abdullah? Can you hear me, Abdullah? Abdullah?
He's probably busy, but yeah, you broke it down though, bro. It can't get more simple than that.
Okay. He looking at me. Can he hear me? So when we talk about these public and private, I don't want you guys to get confused because a lot of people throw that term around. Public and private, public and private. Private is your own personal rights as it relates to the things that you own. And government, when we talk about public, we talk about government and their relationship with the things they own and who they're in contract with, other contractual relationships and their status into whatever intellectual property. So the same thing. So when they talk about public and private don't mix, they are not giving you a true understanding of public and private. Private corporations contract with government all the time. They do mix. You just don't commingle your personal property with your family, right, with government. You keep your family affairs, but some of your business arrangements, private contractors contract with government all the time. You might be in a business relationship with government, right? They might need you to put together some items. People contract all the time. I remember I was looking at a contract with government. They needed an individual will put the screws and bolts. And they send you a big thing of screws and bolts to put them together. That's a contract. It's just you got to understand when you set up your beneficiary rights for a certain family, your children, grandchildren, and all of that, you shouldn't commingle that with government. But you can do business with government. You can do business. You have a right to do business with government. I run a healthcare facility. The healthcare facility that I run is connected. We're an agency of the Department of Developmental Disabilities, in which the agency is an agent of that. And that's a private agency that contract with a governmental entity. So you mixing the two. It's just you don't mix your family affair. I ain't say business, I said family affair. Certain things you want to keep government out of. But your family affairs, that's totally two different things. You want to keep that as separate from government. So let's talk about pros. Flexibility, you can change, and it's private. You got privacy. So what do we mean by privacy as we relates to public and private? When people say this, there is no government intrusion. You don't have to reveal nothing. So in your contracts, in your trust, if it's religious, if it's family, you can have the trustee take a confidentiality agreement. If it's religious, it can take a vow of secrecy. Now, you can tell the government in your relationship under contract, I can't speak about certain things, I'm under contract. I can't testify to certain things, I'm under contract. That's just like a wife or a husband do not have to testify against their partner. This is constitutionally protected. Your unlimited right to contract is constitutionally protected. And you got to understand this. So what is the cons? You have no creditor. You have no Medicaid protection. You can be taxed as the grantor. Why? Why can't the grantor be taxed? Because understanding how you delivered the property, you can be double taxed. And you got to understand how to transfer property. You have to understand, okay? So, give you some examples of understanding when you're transferring property, right? So some of us want to have a corporation, right? Because what you have to understand is how to go about transferring property in your language. If you transfer property where the grantor still has control and may receive benefits, he can be taxed because he's receiving. But if the grantor donates the property to the trust, and he doesn't receive any benefits for that, not from any revenue or proceeds, depending on the language, we can determine how the trust can benefit from it and don't have to, and he doesn't have to rely on paying taxes. It's all going to determine the language that you use. The language is very sensitive to triggering a taxable event. If you don't know the proper language, you can truly activate a taxable event. And if you don't know how to explain your trust, you're going to trigger a taxable event because you cannot identify what you did, which automatically, when the IRS is going to trigger a situation because you can identify and explain what you did. Do that make sense to everyone?
Yes.
So I just need you to be very aware of what you're doing when you're creating a trust. Language is very important to triggering a situation that becomes taxable. You want to not evade taxes, which is a criminal offense. You can avoid taxes by understanding how to properly set up your trust and other trusts and other corporations by using the proper language to associate with such transaction. Do that make sense? What I just said?
Yes.
Okay, let's go on to a irrevocable grantor's trust. A grantor, an irrevocable trust. A grantor relinquishes power to revoke once the trust is executed under the Uniform Trust Code. So they have a Uniform Trust Code book, right? Uniform Trust Code. Have anybody ever heard of a Uniform Trust Codes? So let me do something real quick. Let me pull up. Brother Israel.
Yeah.
About your house.
Yeah, bro.
Could you pull up the Uniform Trust Code for
You still pay taxes on something you already bought? That's not, that is
for
not.
Ohio?
I'm trying to get that. Yeah,
Hold on. It's right here, Title 58.
Let me see. I clicked out. I was trying to pull it up. Where you at? Yeah. Now, this is related to a statutory trust. So if you don't have the proper language, guess what's going to happen? If you don't know how to make it a common law based on your language, guess what's going to trigger? They're going to assume. That's why they use presumption and assumption of law, because ignorance of the law, they say, is no excuse, and they utilize it against you. I know Abdullah gonna argue me down, but the reality of it is they're gonna use your ignorance against you. So click on Ohio Trust Codes. Have anybody heard of Uniform Trust Codes on here?
Nope.
Not one person.
I have.
You have?
I have not.
So how many, show of hands, who have a trust? Because I heard some people say they went to trust classes and they took, these brothers was teaching them how to do a trust. You hear me?
Yeah, I did set up a trust.
But how did you set it up to trust? And do you know these? Do you understand the uniform trust codes within your state?
Not quite. That's the reason why I'm doing this course. So I can learn some things, you know. Yeah.
So, based on your language, I'm telling you once again, the court is going to presume, unless you can articulate what kind of trust you set up, they're going to automatically throw you in this category. Am I making sense to everyone?
Sure.
Click on general definitions. Brother Israel. So, these are things that you need to know. The Social Security is that you have a trust relationship with your social. You don't own it. The Social Security minimum tacit. What's minimum tacit? Or is that minimum contact?
We see it.
Yeah,
Where is he looking?
that's right, brother. You're right. You're right. Language triggered jurisdiction, triggering the minimum contacts because you don't know what to put in there. So, this is statutory language. Actions with respect to act of a trustee include a failure to act. Ascertainable standards mean a standard relating to an individual health, education, support, maintenance with the meaning of Section 2041B1A or 2514C1 of the Internal Revenue Code. Do you see that? Highlight that for me. Highlight that. So, when you go to get a job, the Social Security number is converted into a tax ID number. When you go get a 98 number, a EIN, a ITIN, all of those are tax identification numbers. Understanding the jurisdiction that you trigger. To understand the jurisdiction, you must know the language and why you are applying for such number. And you must know the code sections for that particular number. 501c3s and all the 501c's fall under a particular category of an application of law dealing with the Internal Revenue Code. So is every other thing. So when we talk about a common law trust, as it relates to the fundamentals of a constitutional, Article 1, Amendment 1 of the United States Constitution. They talk about the freedom of religion. They talk about in Article 1, Section 10, or is it 9? The freedom to contract, unlimited contract. These are protected under the constitutionality. They're not in the IRS code. The Constitution protects that. So you got to know the language associated. You have to know the language. And if you don't know how to write according to the language, because you don't understand what you're doing, that's what you're going to do. You're going to create a situation that you don't understand, and if you can't explain it, they're going to explain it for you. The judge is going to come in and they're going to make it out for you because you created a situation you don't know how to explain. So the judge is going to then act as trustee, and then he's going to then look at the situation and make a determination because he has to, because you didn't put it well enough together, contract well enough together, where now you didn't have in your contract what they call a severability clause in your contract. If a provision of your contract can cause your whole contract to collapse, if you don't have a severability clause in your contract. And if you don't know how to write contracts, you can mess up everything you've done.
All right, so we'll do, King, we can, for next class, we can give them examples of severability clauses.
Okay.
I'm taking that down as a, yes. So put that down in your notes too, for next class, examples of severability clauses. Examples of severability clause. So we'll give several, so we'll have that ready for them for next class. This is good because this is information that we do need. As far as this detailed information that you're providing, if you talked about last week, and you gave us some warnings about and legal safeguards to guard against fraud. And we'll be more. You'll give some examples for that as well. But this is these are things that we need to know. As you mentioned earlier at the onset, that there's been misconceptions taught about trust. Not, and then there's those who do teach on trust, not going with it in this great detail as you're going giving us. All right, so I yield.
Okay. And I want you to understand the Uniform Law Commission create all the laws. So the UCCs, the Uniform Trust Code, could you go there for me? I just want to show them something in that. I'm just giving y'all a breakdown and showing you some of the stuff. Go to the Uniform Law Commission, Brother Israel. Just look that up.
All right. Thank you, Israel.
Indeed.
Click on that.
All right, so what are we looking?
Blow
This is
up
our
better,
uniform.
say better laws. Could you blow that up? Could you, where I can read it? Yeah, right there.
Yeah.
Better laws. Since 1892, the ULC has provided states with non-partisan, careful, conceived uniform law. Our work simplifies life for people who live, work, and travel in multiple states, improves local economies by facilitating interstate commerce. Do anybody know what interstate commerce come from? Do anybody know where interstate commerce come from?
Does that come from trade?
No.
From us trading? From back in the day, from us trading?
I mean, yeah, but I want you, when I'm talking about who is directly tied within our jurisdiction to interstate commerce? Y'all need to know these things. I got people on here that say they done took trust classes and you don't know these things.
Is it from state to state?
It can be from state to state, but I want you to understand what interstate commerce really is. So let's go there. So I see y'all need to understand the federal government deals in interstate commerce. Why? Because of the dollar bill, the Federal Reserve notes. That's everything you do and touch is with that Federal Reserve note. So you're constantly in a state of interstate commerce, dealing with that dollar. Now, we talked about buying gold and silver from a dealer that has been certified by the U.S. Mint, and that you can spend gold and silver coins like you can spend dollars. And then you can set it up. They have institutions where you can get credit, they can give you credit cards and stuff like that with those, with having that relationship with those gold and silver coins. Now, you wouldn't create an interstate commerce transaction in the sense of using Federal Reserve notes. That is a private institution. Now you would look at that, and now that's constitutionally protected gold and silver. Now it becomes a question that you can deal with the Supreme Court directly. I just want y'all to understand what's going on, because I see the information that we've been utilizing for its trust. A lot of us is just getting a lot of watered down. They're not getting full substance of this information. This is nothing I made up. You can go. All you got to do is be a constitutionalist. Could you help me out with that, Abdullah, about the gold and silver clause in the Constitution?
Yeah, Article 1, Section 10 of the United States Constitution, Congress shall have the power to Congress should have the power to coin money and to determine the value thereof. And then under state powers, dealing with our state powers, I think Article 5, I believe, is dealing with state powers. The state shall not make anything but gold and silver legal tender for the payment of all debts, public and private. There is a case that I have in Moores and Macy Part 2, Chapter 8 or 9. What's it? Wow, Griswold versus I'll get that to y'all. Griswold versus, well, anyway, I'll tell you a little about the case. Griswold versus someone. Well, anyway, the Griswold was had purchased, had a mortgage, had property, and the owner of the property wanted payment in gold and silver, and not in greenbacks. In fact, the one who oversee, the attorney, the judge who oversaw the case, actually designed. He was during that time. He worked in Lincoln's administration. He was not a judge at that time. He's worked in President Lincoln's administration. He designed the greenbacks. So now, years later, that we have this case. And Oswald versus, I'll get it. It kills me not to remember. Well, anyway, so it was ruled in the favor that Greenback is unconstitutional. That the owner had a right to request the payment in gold and silver. And this is a case that's been swept under the rugs. And I actually found that case as I was working on Moores and Macy Part 2. And I'll send y'all the case. At the Harold Greenwald versus Oswald, something, right? That kills me. I'm gonna stop because this kills me not to remember.
Right. So I want you to understand, it says each uniform act is drafted in an open and deliberative process that draws on the expertise of a state-appointed commission, legal advisors, and observers. So don't you know when you have a trustee, you should have a what? Board of observers. Why? You need to have a board of advisors. Why? When you have corporations, you should have boards of advisors. Why? These are people who are observing, and that these people are obligated to act in a way to help protect the rights of the estates. Most of you guys don't have a trust protector, don't know how to set up a trust protector, don't have the legal wherewithal to put all the proper language in your trust. You're just writing a trust, and then the court is going to assume that it's a statutory creature because you didn't know how to identify and argue that in a particular manner in which you didn't know how to identify the two and separate the two. Do that make sense, family? You can go back.
Hold on, King. Are there any questions? Are there any questions? Are there any questions or comments? Or are there anyone who needs a further explanation on a point that King just discussed? I mean, I know this is a lot, and I knew this would be comprehensive, and we want it to be comprehensive. And I mean, Kang and I've talked at length about this, that we do want a comprehensive course, only because, there's been people have taken different trust class or talked about trust, but not where it's been comprehensive. We need to be comprehensive. We need this. It needs to be a lot. We don't need the watered down. The watered down is not going to get us anywhere. All right. So I want to, appreciate, once again, King, I appreciate you.
Thank you, my brother.
Pardon me. Would you have a template later to show an example during the course of what you're explaining?
I can put something together, but you got to remember, each trust is designed for a particular individual. And I think a lot of us got bought into this idea that we need this whole sophisticated trust when we don't have enough assets or enough wherewithal to create a elaborate, sophisticated trust, because it gets complex. We need to start with the living trust, the will, and build gradually on to those things, because this is comprehensive study. You need to understand, what are you doing and why are you doing it? The who, what, why, when, and where. That has to be answered. You need to understand, why you got a 200-page trust and all of this stuff, and you don't own a car, you don't own the house, you don't have a bank account, and you don't have multiple businesses, but you got this elaborate trust. Somebody tricked you into buying a $5,000 trust. So what we're going to do is we're going to build a community, right? I'm going to have something available after the course, as the course goes along, so we can build a community, so we can then build and stack. So then I could show you, we can interact with each other. I could show you what I'm trying to do, give you some pointers. I want to do to be a lot of you guys' trust advisor. And we work on certain things so that you can grow your knowledge in this information and understand how to do business. because a lot of stuff that we're trying to implement in trust, like Federal Reserve notes, you shouldn't be trying to hold on to it. It's not your intellectual property. It's supposed to be spent to go get assets, create. A lot of us don't even own the rights to your name, your own image. You don't even own the rights to yourself because you don't understand you're supposed to have the rights of publicity over your own self and over your children in a private trust. That name has to be, before it can be released to the public, it has to go through a process through the granting of a trustee to even release it. So the trustee may have to assign you a different identity or name to go on a particular document because this is trust property. It can't go on any document. Brother Israel, I want you to go to Ohio Rights of Publicity. Ohio Revised Code, Rights of Publicity. Blow that up for me. Either or, you can blow this chapter 2 for whatever you want to do. You can blow it up. Click it. It says, now I want you to understand, you have federal and you have state. This is protected under the state of Ohio. But you also can have it protected on a federal level. That's where you go get your name and stuff copyrighted and all of that. You can do it on a federal level. So let's read this. You need to start here. And you can move up. It says,
Students, please mute your phones, your devices. Thank you. Go ahead, King. King, not you.
I didn't mute myself. Somebody muted
All right.
me.
All right.
Okay, let's go over it. Right of publicity. Persona means an individual name's voice, signature, photograph, image, likeness, or distinctive appearance if any of these aspects have commercial value. Commercial purpose means the use of or reference to an aspect of an individual persona in any of the following manners. So you can have an AKA, also known as, right? Keng El Bey. That's such and such and such. You can have your trust hold your name, your family name, so it can't be associated with any commercial activity. And then you can have a business name or another name under contract that can go associated with the Social Security under also known as, in which you can do business through. Protecting your rights under that. Do that make sense?
Yes, it's almost like how like rappers use a different name.
Say that again.
Almost.
I couldn't really hear you.
Like artists, they use like a different persona name when they're on stage.
Yeah.
Versus using their real name when it comes to legal matters and contracts.
Yeah. Exactly. Hope this making sense. Have anyone heard of this before, which I'm talking about? In this particular manner, this in depth. Then it says on or in connection with a place, product, merchandise, goods, service. I want you to see that on, or it says on or in connection with a place, product, or merchandise. What is the Social Security number? It says on or in connection with a place, product, merchandise, goods, service, or other commercial activities not expressly exempt under this chapter. The Social Security number is a product. You have the right not to put you can create a name for commercial purposes. Doesn't mean you're going to be exempt from going to jail. I want y'all to understand that now, but they can't connect it to your trust. They can't come in and take things out of the trust.
I have a question. Hypothetically speaking,
Huh?
when it comes to, I said hypothetically speaking, if it comes to crime, these will be considered white collar crimes, correct? Or
What
because
would
it's dealing with
consider? When you say that, you gotta give me the full information and detail, because you're saying,
white collar. Okay,
no,
but
I'm talking about in specific. When you say this, what are you referring to as this?
like dealing with products, merchandise, goods, and services.
All crimes are commercial. All crimes. So hold on, let's go before we go there. So let's go to United States Federal Code. I think what is it, 7211? I can't remember. So
I think it's 7211. I think that's it.
So I can't remember right off of it. So, Brother Israel, go to under United States codes, all crimes are commercial.
Continue talking, King, because we don't want to have a.
Okay. So I want you to understand that all crimes are commercial in nature. Yep, 7027, 7 CFR 7211. Click on that. So let's look at 7211, meaning of terms as used in this part, the context otherwise required terms shall have the meaning ascribed in the section. Word in the plural form shall include the singular, vice versa, and words importing the masculine gender shall include the feminine. The term includes and including do not exclude things not enumerated, which are in the same general class. So let's go down. And it just giving you a bunch of terms, but keep going. Keep doing what's it. It says commercial crime. Stop there.
Jazz iPhone.
Hold on 1 second.
Can someone read that? Commercial crimes?
Yeah. Commercial
Right.
crimes. Any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. Contraband cigarettes, any quantity of cigarettes in excess of 60,000. Yeah. Yes, that's in the next one. So yeah, commercial crimes. Can't hear you, King. You muted.
Sorry.
You're still
It went
muted.
Okay. I want y'all to think about it. It says crimes against the revenue, offenses against the revenue law. Federal or state offenses against the revenue laws. How do the revenue laws get involved? Do anybody understand? Revenue laws, these tax laws. Okay, go ahead, Abdullah.
The Federal Reserve note.
Exactly. We're talking about minimum contacts. We're talking about things that's issued, right? We're talking about how Congress adopted the Internal Revenue Code. And now they become what? United States codes. They took the revenue laws and codified them in the United States codes, creating a minimum contact, and now creating a jurisdiction, right? And you're triggering it based on a private relationship. When they talk about public and private, don't mix, lie, because the Federal Reserve is a private institution that contract with government. They mix them all the time. It's just about what you mix with government. You don't want your family affairs mixed with government. You can have some business affairs that you're doing and it's set up through a particular entity that is not connected to your family affairs, but you can reap the benefits by understanding how to create your own utopia, by understanding how to contract and use specific language that's outside of the scope of the internal revenue, or the internal revenue recognize this as a fundamental right. And they don't say we can tax this because this is protected under the Constitution.
Terrence, will we be ready for a break in 5 minutes?
Absolutely.
All right, break in 5 minutes.
So I
King.
just wanted to, so let's go back to the outline of the course, how it was broken down.
Yeah, for week 2. Mm-hmm.
Week 2, let's go backward because I ain't even, that's just the first, I'm just on the second term. I ain't even got done with the other stuff. I'm breaking this stuff down for y'all so y'all can understand where the source of law is coming from. Y'all can understand the application of law, right? Understanding the rule of law. These are all the things incorporated to what we're talking about. Findings of facts, conclusion of law. All of this stuff that I talk about, this is how I formulate and understand how the law works. You got a real legal mind here. Brother Israel, go back. Could you go back to the trust stuff we was talking about? The course
the course guide.
Course guide.
Gotcha. Yeah.
All right. Mm-hmm.
Is everyone getting it? I just want to, because ain't nobody asking some questions. I know everybody. You can't. I'm gonna say this. It's no way that you guys understand this information in totality. So I'm asking, nobody got any questions? Not one? This is your time.
Yes, I do have a question about what you were saying about protecting our family name under the trust. So how does that work? Like, so our parents, our names that our parents gave us, they attached a social security to it, not knowing, because they were taught that, oh, we have to get one for our children. So how does that work now as far as like when we are, I guess, just operating in business and commerce, especially as a more, like, do we put the name that our family gave us attached to the social in the trust and operate under whether it's El or Bey or, Ali? How does that work? Because I get confused. I've gotten confused when it comes to that.
So,
I hope I'm being clear.
based on your understanding. So, do you want to keep that family name? Is that really your family name?
Right. Okay.
I'm just gonna ask you. My name is Keng El Bey. I'm
right.
That's my Moorish identity. The Kenneth Gray that was a name that's attached to something. I don't even know all the legacy and history associated with that name. I can't even go all the way back. I only stop at my grandparents. I don't even know nothing about my great-grandparents. Nobody's ever went that far back. I can't go back to my great-great-grandparents. I don't know my great-grandparents or my great-great. So I definitely don't know my great-great-great-grandparents. How many of us do understand that legacy? How many of us can go way back, way back, way back? So we have to be careful. So if you want to have the Bey at your name and utilize your government that your parents gave you, and all of this is taken is a contract. Now, if you want to do vice versa, all you got to do is just change the relationship. Go down to the Social Security. Say, I changed my name for religious purposes. Put your Bey name on there. Put your Morris name on there. And then you start rescinding all the names. You take all the people, right? You let them know I did a legal name change. And now that number that's on that name on the Social Security, you got business credit cards and all of that. Then you could go, once you change all of that over and you get it all the way done, now you just take all of that and you got a car note, you got a mortgage. Now you just have them put that new name on everything, your credit cards and all of that, and create a record that you put them on notice and that this is the name that is now attached, legally responsible for all of that. Do that make sense?
Yes. Yeah, that makes sense. So basically that would just be a name switch. I'm operating out of my Moorish identity, but you're saying attach it to the social. And so how does that go as far as like controlling? I'm gonna just leave it at that for now because I need to formulate my question properly. I need to articulate it.
You want to ask the question? Go ahead.
Yeah, no, I'm just trying to articulate it because I'm going over it in my head because I want to be able to operate in my Moorish identity, but I don't want to. I want to come up from under that straw. I want to come up from under that straw man that's been attached to that Social Security number.
So you saying you want to come from up under that straw?
Yeah.
Why? Who told you to do that? Why? What's your understanding why? I want to know the why.
Because the why is basically I'm not operating well to my understanding. I'm not really operating out of my full capacity. I'm also getting the short end of the stick from what I learned from sure. I'm not sure if that's true or not now that you're asking me that, but from what I've learned is that we're operating from the short end of the stick.
Do everybody agree with that?
When you said I'm sorry. Go ahead.
No, go ahead. Because I was gonna say I had something similar to what she was asking in regards to like how they label us corporate persons versus a living sentient being or something like that. So I had something similar. I like how she was asking that question because I had a similar question in mind.
Okay, but do y'all agree? Because I'm gonna break it down to you. I'm gonna explain it in full and lay it all the way out for y'all. I just want to know if everybody.
I'm gonna say I don't agree at this point in time. Anticipating your explanation only because in certain cases there's a way to exist in contracts. So I don't know if getting rid of the straw man and all of that is really relevant, but I have heard that for years and years and years. I just never thought it was something that made sense to me because contract is contract. Straw man, whatever you can call it, whatever you want, but there's always a way to exist in contract. So it's just where is your position in the contract?
Exactly. So I think you got an idea of it. Anybody else?
I think that as long as we are not operating in our as long as we don't recovery of lost more sovereignty, as long as we are operating outside of our sovereignty, I think that we're going to have the short end of the stick.
So
let me elaborate on that. Let me elaborate on that. Let me elaborate on that. All right, you already know where I'm going. That you have what is known as, so let me use Hawaii. So let me use Hawaii so y'all can understand where I'm going. United States invaded Hawaii, 1993. 1893. Subjugated Hawaii. Subjugation in international law, so we're talking international law, under the law of war. So we're talking international law. If you go to international, if you were to study international law, you have law of peace and the law of war. Volume 1, law of peace. Volume 2, law of war. Oppenheim has 2 volumes. Volume 1, law. You have law of peace. Volume 2, law of war. You have several others that have 2 volumes. On the law of war, you have what's known as acquisition of territory, conquest, discovery, conquest, subjugation, annexation. United States subjugated Hawaii. The subjugation, the element of subjugation is that it creates a new title under subjugation. So when United States subjugated Hawaii, they gained what's called territorial sovereignty over Hawaii, thereby creating a new title. They put the queen under house arrest in Home Palace. Another element of territorial sovereignty is not only does it that the United States gain control over the territory of the King of Hawaii, they also gain control over the inhabitants, the native people of Hawaii. So now you have what's known as a change of sovereignty. So the King of Hawaii loses her sovereignty. So you have what's known in international law as a change of sovereignty and its effects upon the inhabitants of the land. In order for y'all to understand that, you have to understand international law. It's the only way. The only way you can understand, you have to understand what I'm talking about, the elements of international law. So there's a change of sovereignty and that the effects that it has on the inhabitants. Now United States has what? Control over the inhabitants of the land. By virtue of that, gaining territorial sovereignty, another element is that the subjugating state, i.e. United States, can determine the status of the native people of Hawaiian, which the United States did. So the United States Code, Title 8 of the United States Code, 1900, United States, and redefining and constructing a status for the subjugated people of Hawaii, placing them in the United States jurisdiction, all right, through legislation. And those are elements. So as long as, so that's gonna talk to us about us now. Ain't no conscious Moor can ever have an allodial title. I don't care what they say. So as long as our land is in a conquered state, they can talk with their allodial title stuff all they want. United States has territorial sovereignty over our land. United States didn't conquer. France did. When France conquered, France created a new title through subjugate, through conquest. France, under the French crown, Louis XIV, France created, surveyed the land, surveyed the boundaries. The survey map became the new title under conquest. France transferred French territorial sovereignty to Spain through treaty 1762. The treaty, the application of law, is different than that of subjugation. Subjugation establishes a new title. The cession treaty transfers an existing title, two different applications. All right, both fall under acquisition of territory. Both fall under that, but there's different applications. All right, so you have a creation of a new title under subjugation. Thank you, King. Thank you, King. You have the transfer of a new transfer of an existing title, the 1762 Fontainebleau Treaty, Treaty of Fontainebleau, 1762, between France and Spain. So now Spain has territorial sovereignty over the territory, Louisiana territory. France retrocedes the title, the territory sovereignty to France in 1801. France in turn transfers the title to the United States in 1803 through the Louisiana Purchase Treaty. Once again, another element of territorial sovereignty is that if the status of the inhabitants is not mentioned in the treaty, then the United States can determine the status. But the King of France negotiated the status with the United States of the French subjects. In the Louisiana Purchase Treaty, the French subjects became citizens of the United States through the treaty. So the status is negotiated in the treaty, but not ours though. Our status was not negotiated. So therefore, United States can determine. So United States, so as long as our lands, so we have that. So France, so United States gained acquired territory sovereignty over Florida, 1818 treaty with Spain. United States gained territorial sovereignty over the 13 states. Gained territorial sovereignty. The 1783 definitive peace treaty between United States and Great Britain. You have United States gained territorial sovereignty over California, Arizona, Nevada, Utah, Texas, through the Guadalupe Treaty. In that treaty, another element of territorial sovereignty, I'm just breaking it down in details. Another element of territorial sovereignty is that the inhabitants can have an option. In the Guadalupe Treaty between Mexico, United States of Mexico, and United States, the inhabitants, the Mexicans had an option to remain a citizen, to remain a Mexican national, or become a citizen of the United States. The treaty allowed an option. That's another element of territorial sovereignty. This is all international law. So until Terrence is correct, so I'm providing support with Terrence is saying. So as long as our land, as long as we have not recovered our lost born sovereignty, and the United States maintains territorial sovereignty over the land, that gives United States the right to determine the status of the inhabitants. Do what? Do that, because remember, the United States did not conquer, France did, Great Britain did, Spain did. So we have to address that. We have to recover our lost born sovereignty. and recovering our lost more sovereignty, we in turn addressing the status of our people through a pre-existing status. But we have to recover our lost more sovereignty. I heard my brothers and sisters, all they get heard are misconceptions. I taught misconceptions for 25 years, so y'all heard it from me too. So forget what y'all heard from me 10 years ago, 15 years ago, 20 years ago. Yes, you can quote me what I said 20 years ago. That was incorrect. Yes, you can quote me what I said 15 years ago. I was incorrect. Yes, you can quote me what I said 7 years ago. All I said was 15. You got to go back 6 years. Prior to that, everything had said about we're 35 Moors and we're part and parcel of the said government and, all that. So I just wanted to provide in detail, with specificity, what Terrence was talking about.
All
He's
right.
100% correct.
All right, we're going to go to break and
Got it.
7
Thank
minutes?
you.
When I come back, I will break this down. I'm gonna show you what you can do, understanding the right of publicity in the social.
All right, all right. All right, thanks, Abdullah. Here we
You're
go.
welcome.
So let's look into this, because I'm gonna break this down about what the sister was asking. We're gonna get into what Abdullah was saying in relationship to territorial sovereignty as it relates to jurisdiction and understanding the jurisdiction that you're in. So, under the territorial sovereignty as it relates to us as Moors, as native people to the land, we are in a state of subjugation and cession. Okay? That's your current status. But through that status, they recognize you through legislation. And they gave you some fundamental rights. And how all of this stuff intermingles. So I know a lot of y'all say, I want to get rid of the straw man, like that is the issue. No, the issue is that we lost our sovereignty and we have to resurrect our mother so that we can have a voice in the international political community and take our rightful claim back over the land. That's how we gain control. But for this sake, I'm going to keep it simple as it relates to Social Security number. Now, how many of us have children? Do anyone have children?
Yep. Wow.
Okay.
Yes.
Okay, so when is your children grown?
Yep.
No.
So if your children that ain't grown, right? How do you utilize the Social Security number for your grown children? Can they contract with their Social Security number? Yes or no?
No.
Yes.
Yes, because what about school, for instance, like when you enroll your children
No, they can't.
in
No, they
school?
cannot.
Okay,
no, your children cannot. How do your children enroll in school? They don't go on their own and contract on their own.
No, the parent does it. But is that contracting your children in a sense, because they do ask for the social and the birth certificate?
But you are acting as in a capacity to contract for your children because they are not in a contracting capacity. They're not of age to contract. So how can they contract? Any contract they get in, if somebody got them in a contract for a credit card, it would automatically be dismissed. Why? Because they cannot contract. They're not of the legal age to contract. You know why I'm saying this? Take a guess. Do anybody understand why I'm talking like this in this capacity?
Because then they wouldn't be bound to the Social Security number.
The reason
Because you're a minority as well.
that has nothing to do with that. It has the ability, we talk about contracts. So the same way I got 4 young children, right? I do all the contracting for them. They can't contract. You can set up the trust to be the same guardian. And the trust can then be assigned the social security number. And you have to get approved from the board of trustees. And it may assign a name, an identity associated with you so you can contract. The same way you took control over your children's life, you can set up a trust and do that for your family, and that can be a whole nother trust. Do that make a little sense to y'all?
Make a lot of sense.
You understand what I'm saying? So what I'm telling you is your wherewithal of understanding legality, to understand what you can and cannot do. You have an unlimited right to contract. The government cannot make you put your family name on anything. You do it. Everything you do is voluntary. You need to understand your ability to contract. So some of us don't need to be in position to contract with the Social Security number. You need to assign everything over to a trustee who is a payee of that estate associated with the social, and it can do it for the entire family. And now you have a trustee. Before you go sign a car note, mortgage, and all these other contracts, the trustees say, no, you can't contract in that capacity. I'm denying you the right to contract because we don't have the funds or the necessary components for you to contract in that. Or it can then line veto contracts, school contracts, and other various contracts in the trust, where it can negotiate the contract and how that number can be associated with the trust or the individual due to the fact that the individual is being indemnified and only the trustee and the board of trustees is liable under the trust. But their liability is backed by gold and silver as a indemnification bond for any and all debts. And that will be issued to pay off debts. I know I'm going in a little bit. But these are the things that y'all have been taught. Somebody that told you that don't use the social, don't do this. And it's all about your understanding, your ability. That's why it's called trust and contractual safeguards. You guys do not know how to safeguard your rights, yourself, your children, and everything you do, because ain't nobody talk about no contractual safeguards. All they did was tell you to set up a trust and don't use the social. And the social is not going, using and not using the social is not going to keep you out of jail. It's not going to keep them from taking your kids. It's not going to stop them from coming in your house. Because, like Abdullah said, they got a territorial sovereignty. This is an international law issue. And we must resurrect our mother to be able to defeat such claim and raise another issue, to raise the proper issue under international law. I hope everyone is getting this. Abdullah, where you at? Abdullah.
That's awesome, brother. To see it getting dressed. Awesome. Yeah, you on it. You on it, brother. You on it. I was cheering you on, brother.
Am I explaining it right?
Oh yeah. I'm cheering you on, brother.
So I need y'all to understand this information. Okay? So it's all about contracting. I don't want to overstimulate your mind with international law. We'll probably have another discussion, maybe another class in that. But that is a whole nother gambit of information that you have to be able to have the ability to absorb. Me and Abdullah have been breaking this down. Okay, my brother. You got a question? Glenn, you got a question?
Uh, I probably do, but I just don't know how to ask them.
Well, shoot, maybe we can unravel the question.
Well, okay. Man, what-
Do your best, man. Do your best.
yeah, I am.
I have a question if Glenn wants a moment to think of how he wants to ask his question, or I can wait if he's ready.
Oh, you go right ahead, ladies first.
Maybe a quick one. So I just want to know if there was a difference between a trust and a conservatorship, or function the same, or they are the same and just interchangeable terms.
A conservatorship, right, and a trust, right? All of this is a trust relationship. I want you to understand, it's all trust. This is all trust. Corporations, individual, this is nothing but trust status. This is relationship. It's all trust, right? A conservator is a particular language for a particular trust to behave, a trustee or a particular individual to behave in a certain capacity. But everything is a trust. A LLC is a trust. A sole proprietorship is a trust.
So the trust would be the umbrella and all those would fall underneath that.
Right.
Thank you.
So they say, well, no, that's not a trust. A trust, so the reason why it's all a trust, let me explain to you why. So you may have a private trust that has a certain dynamics listed with a whole bunch of individuals and how y'all can contract. But then everything you do set up through the government, your social and all of these statutes and codes, what you think those are? Those are trust terms. These are all terms. Everything is a trust. You are connected to something. The reason why you in the government that's a trust relationship. It's a trust relationship. You are trusting the government to act in a certain capacity as they're trusting in you to act in a certain capacity based on y'all obligations to each other. That's a trust relationship. It's all trust. But they're going to tell you, oh, this is a trust. They're going to have estates, individual, all of this stuff. It's all trust. It's just different language and different forms of trust that is then determine how each type of entity should behave. And it's based on the language.
What would be the component?
Do that make sense?
Yes. Yes, that was helpful. Thank you.
You're welcome. You're welcome, Amanda. Now go ahead, Glenn.
Okay, let's say I want to set up a trust to do business like trading on the Chicago Board of Trade. How would I go about doing that? And what would be my intentions? Okay, what's my intentions for that? Well, to protect my assets and protect my name, protect myself.
Hold on.
Okay.
You see, here we go.
Okay.
You said, help me create a trust to do business with who?
Trading, like with on an exchange with a
Okay, that is the intent. It's not to protect your assets, it's to do business and do trading.
Okay, all right.
Right?
Yes.
Okay, so you would set up a trust associated with the events and the transactions associated with the business relationship that you're trying to create. And then you will put the proper language and the proper people in place that are experts or who have the best field of study in those positions so that you could create a favorable position when setting up that trust so that you can yield the most earnings. Do that make sense?
Yeah, that makes a lot of sense.
Then, if you're trying to protect the assets, then you would say upon transfer of assets, the assets will then go to a holding company that then will protect the assets and have an obligation to protect the assets and may not release the assets unless advised by the board of advisors for whatever reason or whatever to release such assets for reinvesting or to future beneficiaries for whatever purpose. I don't know. I'm just giving you a synopsis of an idea because this trust thing is based upon your understanding. Do that make sense?
That makes a lot of sense. Thank you.
I don't have to, don't know, I'm doing this because I can do it off the top of my head. Don't know why I don't have to read a book anymore. I understand law. I didn't been studying for a long time, so I understand everything is a contractual relationship. And I have to understand how to create these relationships, how I want these entities to behave with each other, and how they need to behave with the government. Am I making sense, family?
Yes.
Yes, I don't know if this is off topic, but I have a question from something I've been hearing. Basically, how United States is a federal corporation, and I hear you use the term government. So I'm trying to, what is the distinction as to what you're describing, please?
You're saying that the United States, so let's break this down. Under international law, the United States, right, it was formed through treaty and international law. It was recognized under international law. What you're reading is a statute. International law becomes before a domestic law. A state is formed under international law. You cannot have a state, right, a government without having international law applications that then yield you under international sovereignty, where you survey the land and all of that.
Excellent.
United States Code.
Excellent. 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 Woo.
United States Code come under a domestic after the formation of government. After the formation, then you have the Constitution that creates the body of government and how it functions. They gained territorial sovereignty over the inhabitants and made them subjects of the subjected to the jurisdiction thereof based on their international status as a state, as having statehood. Then you got United States Code that is recognized by Congress. The Constitution created three branches of government. They are creatures of Constitution. Then Congress created United States Code, and it talks about what? United States being a corporation. So what do? Congress created a corporate fiction to do business through. But you got to understand international law. Two different things. Do I make sense, brother?
Yes, appreciate that. Thank you.
You're welcome. Abdullah, did I do a good job at that? I'm just asking Abdullah.
A plus, A plus, plus, plus. A plus,
Okay.
plus, plus. Woo. Man, you knocked out the park, brother.
So I'm just trying to get everybody to understand how this trickled down. International law, then you go into domestic law, right? Due to the constitutionality, and then it allowed the three-headed branches of government to create its own bodies, and then Congress under the Constitution had to right, to legislate law. And each branch of government had, under separation of powers, control their particular jurisdictions. You have to understand, you have to know international law, you have to be a constitutionalist, you have to understand these things to be able to identify this. It's very important that you understand this. There's a lot of people gonna say, well, it says that the United States is a corporation. Congress did create a United States corporation. It did. They had the power to do that. But the United States of America is a state and it's recognized internationally. So we got to understand that. So let's move forward. I haven't even got out of section 1. We got about an hour left. So I got to start moving. Any trust, living inter vivos trust, any trust revocable or irrevocable formed while grantor is alive. Same as the above, but activated immediately. Immediate management and continuity if grantor is incapacitated. Non-unique beyond revocable, irrevocable phase trades off. So you got to understand how this works. And when it comes to trust, right? So the government, like with the social, right? A lot of people don't know, you created a trust relationship with the Social Security Administration. But you can control how you attach yourself to anything. You get to control how you attach yourself to it. You get to control who has the jurisdiction to utilize the social. You can say, my family members cannot use the social, that the board of trustees they're the ones who must utilize that social for our benefit. Because they're experts in it. They know how to do business and trade and commerce. You put the right people in the driver's seat to do the type of business you need to leverage your estate. Do that make sense, family?
Yes.
So it's just too many people teaching stuff because they don't understand law. Testamentary trust. Trust terms appear in the grantor's wills, spring into existence only at the death and pass through probate. Minor child trust, marital/credit shelter trust, probate court supervised and can add accountability, use, and will formalities. No privacy, probate file delayed until estate is closed. So just having a will, you didn't put it into a trust, so the government, by your own failure to operate in the capacity needed to safeguard your rights, you left it open where the government, you gave some instructions, but you didn't assign certain people to it. You didn't assign your will to a trust. And so now the government is assigning itself to the will because you didn't know how to properly assign it to the living trust, where the living trust now takes control over the estate once you die. Special needs trust, okay? Drafted to preserve a beneficiary eligibility for means-tested public benefits, SSI and Medicaid. I want y'all to look at that. Special needs trust, drafted to preserve a beneficiary eligibility for means-tested public benefits, SSI and Medicaid. Disabled beneficiaries require lifetime subsidies, right? This is where you might have a child with autism or something, then you can set up a special needs, but you can also set up a special needs for you and your family because y'all don't know the law associated with the Social Security number because it's so vast. You can set up a special needs trust where the trustee take over for you and your family that deals with all the business transactions to benefit you and your children. You can put the social security number in a trust. It says benefits not counted as resources, professional trust management optional, the Social Security Administration has strict rules for this. So you must know what they call the POMS, POM. You must know POMS. That's the Social Security Administrative rules. So let's brother Israel, because I gotta go through this next hour. I gotta go through a lot of this stuff. Could you go to POMS for me? Go to POMS, POMS. So go to Social Security Administration, POMS. POMS. You there, brother Israel?
Yeah, I remember. I pull it up.
See y'all getting a bang for y'all, buck, because I know when nobody teaching y'all none of this stuff I'm teaching you.
Mm-hmm.
Click on it. Now go over to right where it says table of contents. Click on that. And it talks about a lot of different things, right? Let me see. I want to talk about they talk about trust in here. Trying to see. I'm trying to see the special needs trust, special system health supplement, general records.
You disability insurance?
It might be that. Go into there. I'm trying to see. They gotta go to search. Go up there where it's in blue. Hit search. Go to special needs trust or spend. What is this? Thrift trust. What? Okay. Now go down. Go all the way down. We'll see. They got Kentucky. Let me see if they got Ohio. Click Ohio. Click Ohio. The anchor for special needs trust is pooled special needs trust agreement. So this is the stuff. It says syllabus. In this opinion, the regional chief counsel examines the anchor for special needs trust, pooled special needs trust, to determine whether it is in compliance with the procedure governed by the agency trust policy. The RCC concluded that the trust does not meet the requirements for the pool trust exception under 42 USC 1396 PD 4C. Among the key deficiencies are non-compliance with the requirement regarding management of a pool trust by nonprofit associations, failure to adequately address individual accounting, and failure to meet the sole benefit requirements. Go down. It says opinion. You asked whether the anchor for the special needs incorporated pool special needs trust as amended on December 19, 2020 is in compliance with the procedure governing the agency trust. I just wanted you to see, right? Okay, that this associated with special needs trust. Now go back up. Now his search again, I think go to thrift trust. I think it's a spend some thrift trust. I can't remember. We got it. Or just put in thrift trust. Now, let me see. Tax exempt and other plans. So go to a federal thrift saving trust. So they go up to the first one. They got a federal thrift saving fund. A federal thrift saving fund is treated as a trust in section 401A of the Internal Revenue Code. Therefore, employers' contributions to the funds are not waived. Elective employment contributions to the fund. So they have different types of trust, right? You just have to understand in connection with that Social Security number. If you want to set up a trust, you can set up a trust associated with their social, but then you need one that is then in compliance with the Social Security Administration under their rules on what you can and cannot do with the trust. And you got to remember this: you cannot take control over someone's social, and that social is not being used directly for the benefit of that person. That is a misuse of trust, and you could get in a lot of trouble. So we could go back because I gotta get through this. Is everyone catching on?
Yes.
A little bit.
Who said a little bit?
Nadine.
Oh, Nadine, what's wrong?
Well, you have things like Social Security insurance. There's a thing of Social Security disability insurance, pensions, and that's not reflected in the information. And those are things that I have.
Right.
So I'm trying to,
those are different things that you can qualify under having that Social Security. Those are Social Security benefits. That's in particular to what you qualify for, right? So how you want to take your name and identity and use it, right? That's another form of relationship outside of the government. They don't have no control over that. But I just want to go into some of the other aspects. So us as who's taking this course, and those who don't understand, like I understand, what options they have. So do you have a particular question in mind?
I have a question related to what Nadine was just referring to.
All right.
So with whether it's the Social Security, disability, or Medicaid, where it would kind of fall under that special needs trust, is there some type of trust language that whomever is receiving those benefits has access to that is created by the government first or separate from someone creating their own trust, their own special needs trust in order to disperse those benefits in accordance with how they want to, that's different from the government? And like
well, so when you use that name, special needs trust, you're going to trigger jurisdiction. You're going to trigger the jurisdiction. Language triggers the jurisdiction.
You're receiving the benefits from the federal government.
So what you want to do is have a right of publicity set up where you got contracts where you have You could do an alias and then through a contract, through a trust, through a common law business trust, you can set up relationship that then that common law business trust could set up a particular trust for particular individuals associated with that family, and that the board of trustees were governed for the benefit of those individuals. Due to their inability and their capacity to know law, that then they may have a law firm or whatever, because a lot of people do set up with a law firm that can then take over control and utilize those socials in the capacity necessary for the family to directly benefit from, where it's a more favorable condition than not. So it's just a lot of information. And I just haven't got through the first section. Designed to last multiple generations. We're talking about a legacy and dynasty trust, often as long as a state rule against perpetuities allowed or in perpetuity were abolished. So that's just dealing with the states and how they look at, perpetuities. And that can vary from state to state, even country to country. Family wealth preserve, GSA tax planning, long-term creditor, divorce protection, compounded investment growth requires careful trustee succession and state situs planning. Now let's go to the second. You guys will have this access to the video. Go down to 2. Trustees' responsibility in managing trust assets. Duty of loyalty, act solely in the beneficiary interest, avoid self-dealing under Uniform Trust Code, Section 802. Now, that can be different in your state. So I'm just breaking some stuff down. Duty of prudence, invest and manage per a reasonable investor standard, Uniform Prudent Investor Act. Duty of impartiality, balance competing interests of income versus remanded beneficiary. Duty to inform and report. Keep beneficiaries reasonably informed. Record keeping and accounting. Maintain books, deliver periodic accounting or court reports. Tax compliance. Obtain an EIN, file a 1041 and any state return on time. Safekeeping. Segregate trust assets, avoid compelling with commingling, segregate trust and avoid commingling with personal funds. So you never have a personal account tied to a trust. You can set up a business like an LLC that could then hold the funds or whatever. And that's how that works. Let's continue. Protocol to revoke or modify trust. Revoking ordinary revocable trust. Trust instrument plus state statute. Grantor signs a revocation, often notarized. Delivered to trustee. The trustee retitles and distributes assets back to the grantor. Do everybody understand what that means?
Not really.
How you doing,
Revocation, often known as delivered, trustee, title, distributes assets back to grant. And
go ahead, man. I see you unmuted yourself too.
Well, I just wasn't, I wanted to just confirm if you were asking if we understand what it would mean to revoke or modify a revocable trust.
Right, I'm just saying in this, based on what I read, do everybody understand what was just read under one?
I understand it.
So Glenn, you still don't understand it?
I'm reading it over again. My grandson delivered it. Okay, I get it.
Okay. So this, I'm gonna explain it real quick. A
Mhm.
grantor would sign a revocation agreement that if something happened, that he would then, he would sign all the assets over to the grantor. And then the grantor either would find another trustee or redistribute it to the trustee with a better contract or better terms and conditions. Do that make sense?
Mhm.
It's just where the grantor safeguard his rights. If anything was to happen, then he can request the trustee to give him back his property.
Oh, okay. All right, that
Then,
was something.
yeah, amending or revocable trust.
Same authority.
Same authority, executed amendment or full statement delivered to the trustee upon asset title. Modifying an irrevocable trust, UTC. State, the Canton Act or court's equitable power. State the Canton Acts or court's equitable power. That's on the contract, depends on if it's a statutory trust or not. Beneficiary consent and court approval 411A and or B anticipated circumstances, doctrine or trustee initiated decanting into a new trust or non-judicial settlement agreement were allowed.
Okay, what did that mean?
Okay, so the beneficiary got a consent. It's a form, a 411A form, and then it's a unanticipated circumstances doctrine. Trustee initiate decanting into a new trust or judicial settlement agreements were allowed. So that's just where the trustee, the beneficiaries, they sign over, right? They either gonna remove the trustee, sign over property, where then it could go to a new trust, right? Where they're utilizing, because beneficiaries can vote out sometimes trustee, they have to file a complaint to what they call the trust protector, and upon review, the trust protector can remove the trustee and then have these properties sorted out to a new trust, or removed to a holding company, or anything allowing the trust, all the business in that trust to be settled and handled. Terminating, I can't see that, brother.
I can read it. Terminating an irrevocable trust. Sorry. Governing.
No, manner, you can read it.
Same governing authority for terminating an irrevocable trust, and a full beneficiary consent is needed if no material purpose remains, court order, or automatic per trust terms or date.
Do everyone understand that?
Purpose.
Yes, sir. Yep.
So, okay, So if you terminate a trust, do anybody understand how trusts are terminated?
No, I don't.
Okay, let's say you might have a trust for 7 years. A lot of y'all don't set up your trust right. Within the 7 years of the trust, the beneficiaries can say the life of this trust, or the grantor can say the life of this trust can only exist for 7 years, or it would go into a dissolution state. It'll be dissolved, right? It'll go in not dissolution, it will go into a dissolved state. And that the beneficiaries can have to have a vote to resurrect such condition of the status of this trust, right? And then the material then can go to the beneficiaries, or the assets can go to the beneficiaries or transferred to another trust upon how that trust is set up. It can either go through court order where the trustee is not trying to obey the terms of the trust, then the court can get involved, and the beneficiaries can sue the trustee and have him removed. And then it's automatic per trust term. So everything you need to do, you need to put it in there correctly, and that you have your trust safeguarded from fraud, and that the trust can then be utilized properly, and all the assets can be protected. Does everybody understand? Hold on 1 second.
All right, so we have revoking an ordinary revocable trust. If this will review scenario, governing authority, trust instruments, state statute, amending a revocable trust, modifying irrevocable trust, terminating an irrevocable trust. So you see what's involved with this.
So
are you ready? All right.
You need to understand that a trust can go for 99 years before it dissolves. You got to have all that language in your trust. You just can't create a trust and you don't know the length of the trust. That the trust may have to be renewed every 7 years, or every 15 years, or every 20 years. That need to be in your trust. Who can keep the trust alive? Is it that the beneficiaries have the right to dissolve the trust? Who has the right to dissolve the trust? And where do the assets of the trust go? Do it go to a holding trust that then may create an escrow account for the trustees if they're set up a escrow account to be held for minor children until they reach the adult age to contract? It's so many things that I know a lot of you guys are trying to set up a trust that you're not thinking about.
How is the length of a trust determined?
By you.
Okay.
By you. What you want to do with it, based on your knowledge and understanding.
Oh, so there's no limit to how much time I want to extend the trust out to? If I want to do
most trusts throughout the state, the longest you normally can have a trust is 100 years.
Oh, okay.
You can't set up a 1,000,000-year trust. They're gonna look at you and say, "Is you crazy?" Because
So
you gotta
when you use the word perpetuity, the length of the trust,
that means you talking about continuity.
Okay.
Perpetuity. Continuity of a trust, not perpetuity.
Oh, continuity. continue, the continuation.
Yes.
Okay.
Interesting.
Do y'all want to take a break or just take it to the rest of the to 5?
Yeah, let's take a break.
All right.
For how long?
7 minutes.
7 minutes? Okay.
Yeah. Go down to, okay, we finished with this. Let's go down to section 4. Why constitutional foundation matter to trust?
Yeah, this is it.
Okay, contract clause. Trust is treated as a private contract. State may not actively impair vested rights. Do anybody understand what that means?
Retroactively impair vested rights.
Yeah.
Impair means in this. What do they mean by impair in this case?
Impair means to take away or disturb rights, to pretty much take away or remove rights, or yeah, pretty much.
Okay.
Be an example by if me and my baby's mother had a contract on how we was gonna raise our child, an agency or a state just can't come and input themselves into our relationship as far as the child goes. That would be correct?
Somewhat, because you got to remember, the government has a duty. If you and your child mother was harming the child, they can come in. But I'm gonna give you an example. I'm gonna give you a prime example. Let's say that, let's say you and your baby mom, right? Something happened to one of y'all, right? Or y'all having a contract that upon y'all death, the children would go to their grandmother, right? The government can't turn around and say, no, the children can't go to the grandmother.
Okay.
You see what I'm saying? Because it was already vested into contract. They can't disturb the contractual relationship, especially if all the criteria met under the contract of the grandmother. Like, let's say y'all died, y'all had a home that the grandmother inherited the home. Let's say both of y'all died in a car accident. The grandmama would inherit the home and all the funds. Let's say y'all had a life insurance policy of $200,000-300,000 that she inherited that for the beneficiary for the children if they were still young. The court cannot come in and change the situation around to meet a public scheme or need.
Gotcha.
Do that make sense?
Yes. Now, is there any time when the state can come in and
I explained to you. If you hurt the children, if you harming them in any way, that they see that they have to come in. That's under law.
Okay.
So, for 5th and 14th Amendment, due process taken. Government cannot seize or rewrite trust property without due process and just compensation.
That makes a lot of sense. That one speaks for itself.
Article 3, case or controversy, standing rightness. Beneficiary seeking federal review must show concrete injury. Many trust disputes stay in state court unless a federal question, e.g., GST, general state, what is it? statute arises?
Seeking. Right, that's beneficial. Seeking federal review must show ounce of great injury.
So what they telling you right there, if you a beneficiary, right? Let's say you're trying to get a trustee removed, and under the only way in the contract it says, under the trust agreement, it says that the trustee only can be removed if he presents certain harm or injury, right, to the beneficiary. The beneficiary gotta show where he was harmed, financially or whatever. And then it says many trust disputes stay in state court unless a federal question. That means dealing with a constitutional right or a right that's protected by the Constitution. Oh, man. Ashwander avoidance doctrine. Court decision cases on non-constitutional grounds when possible, and interpret trust under UTC before reaching due process claim. So you got to understand the Ashwander rule as it relates to the Supreme Court doctrine. So we got to understand that. Dealing with this, it was a case, Ashwander versus something, and the court made a discovery about certain things dealing with that. Y'all can kind of look that up since y'all got, it's called the Ashwander rule. Generation skipping transfer, okay. Oh, okay, that's what it means. Generation skipping transfer. Separation of powers and legislative remands. When a trust tax statute is ambiguous, courts often let Congress amend rather than declare it unconstitutional, preserving stability. So, oh man. So when we're looking at the separation, right, so one of the things we always look at in law is ambiguous language. Because if it's too ambiguous, nobody can figure it out. Come on to the sixth one. Okay, why the trust instrument language control management? Anybody would like to read?
I'll read.
Okay.
Why the trust instruments language controls management. Sole and absolute discretion grants trustees broad latitude. Courts rarely second guess. The HEMS standard, health, education, maintenance, and support, imposes an ascertainable guide and protects from estate inclusion under Internal Revenue Code sections 2041 and 2514. Mandatory versus discretionary distributions influence beneficiary standing and creditor access. Co-trustee clauses, majority versus unanimous decisions dictate oversight rigor. Removal or secession provisions prevent stalemate and protect continuity of asset management.
Okay, so a lot of y'all need to understand these trust language for controlling, right? So a lot of this stuff you need to be familiar with. That's why trust is not so cheap when you got a real trustee. I mean, when you really got somebody really writing your trust, because they have to be astute in a lot of different areas. tax codes, uniform trust codes, statutory language. Like you can have a trust company, a trust that owns companies. And who owns that trust that owns those companies, and who posted, where the beneficiaries posted, how they benefit from all it. It's just, it's so many different things and areas that can be covered. And how all of this stuff works. When we talk about dissolving the trust, who gets the assets, removing trustees, who has the power to remove the trustee, who can be a trust protector, who can be a trust advisor. All of these different things you need to understand when setting up trust. Okay, go ahead to the next one. Brother Israel. Do anybody want to take a turn, get y'all actively involved? We got 20 minutes. What time was we cutting it off, Abdullah?
Probably about like 5 after. I believe that's
Okay.
probably around the time we got started.
Okay. Anybody want to read this?
I'll read it. Benefit, probate avoidance, revocable trust, irrevocable trust. Okay, ability to change, high, low court or consent required. Incapacity planning, successor, trustee steps in, excluded, but grantor usually excluded. Asset protection, Medicaid shelter. If look back, satisfied. Estate tax savings, included in state, removed at funding. Income tax flexibility, income tax to grantor, separate taxpayer unless grantor type. Privacy from creditor, divorce, minimum, strong, subject to fraudulent transfer limits. Okay. You want me to continue?
I'll go.
Okay.
I'll go. Benefits comparison, board oversight in a revocable trust, grantor as initial trustee may appoint co-trustees or a trust protector board to review investments and compel audits. Multi-signature requirement for major actions, selling a family business, ensures transparency. If grantor becomes incapacitated, the board already in place maintains continuity. Irrevocable means irrevocable. Once assets are transferred, the grantor cannot claw them back or reorder beneficial interest except through the narrow avenues in UTC 411-417 or state decanting statutes. Creditors likewise face higher barriers subject to fraudulent transfer statutes.
Anybody want to read this?
Trust constitutions and Ashwander, putting it together. 1, threshold doctrines, standing, mootness, may bar federal jurisdiction in trust disputes. Parties often litigate in state probate courts first. 2, Ashwander Rule Number 1, constitutional avoidance. If a fiduciary duty claim resolves the case, a court will avoid opining on the due process takings issues. 3, legislative cure. When a trust tax statute is ambiguous, courts frequently stay enforcement to allow Congress or state legislatures to amend language, e.g., a generation skipping transfer tax revisions in 1986 and 2001. Quick reference mnemonic for students: RILTS, BIC, RILTS, BIC, revocable, flexible, irrevocable, immovable, living, lifetime, testamentary, triggered by will, special needs, SSI safe, board oversight is revocable, immunity shield is irrevocable, constitutional guardrails, the Ashwander and Contract Clause. Uniform Trust Code UTC definition and key points. The Uniform Trust Code is a comprehensive model statute drafted by the Uniform Law Commission and first approved in 2000. It is not federal law. Rather, it offers states a template that modernizes and standardizes trust law, so practitioners will encounter largely the same rules from one jurisdiction to the next. States adopt the UTC by enacting it, sometimes with local tweaks into their own probate or trust codes. As of 2024, 36 states plus the District of Columbia have enacted some version of the UTC, and additional states, such as New York, have bills pending.
Okay. Anybody else, or y'all want me to read it?
I'll go again.
Okay.
Okay, is that the page that says probate or trust codes? I don't think the last paragraph. Was the last paragraph read on the last page?
I correct structure articles 1 to 11.
That's where it's at. Can you see that?
Okay, you read to that. Okay, copy. Okay, structure, articles 1 to 11, general provisions and definitions, scope, governing law, choice of venue, judicial proceedings, subject matter jurisdiction, virtual representation, creation, validity, and modification. Requirements for making, amending, and terminating revocable and irrevocable trusts. Creditor and spendthrift issues. Rights of creditors, spendthrift clauses, special needs rules. Trustee's office. Acceptance, resignation, removal, and successor selection. Revocable trusts. Default rule that a trust is revocable unless stated otherwise. Proceeds for revocation. Trustee powers and duties. Incorporates Prudent Investor Act standards, lays out fiduciary duties, loyalty, prudency, impartiality. Liability of trustees and rights of third parties. Breach of trust remedies, statute of limitations. Uniform Prudent Investor Act, if not separately adopted. Liability of former. Somebody's talking. Okay. Uniform Prudent Investors Act, if not separately adopted. Liability of former trustees and certification provisions. Miscellaneous, electronic records, transitional rules. By the UTC, by the UTC matters. Uniformity replaces a patchwork of common law, doctrines, and older uniform acts. The 1937 Uniform Trust Act. Flexibility codifies ways to modify irrevocable trust, UTC 411-417, through court order beneficiary consent. Creditor rule, provides clear spendthrift and asset protection provisions while balancing creditor rights. Modern concepts expressly recognizes revocable trust, incapacity planning, trust protection, and directed trusts. Topics barely mentioned in earlier statutes, court efficiency, supplies default rules and fills gaps so judges need not reinvent the wheel when adjudicating trust disputes, promoting predictable outcomes.
That's it.
I'm here. So a lot of y'all don't have it where, like, for example, people touch your credit card all the time. Where can you do an audit with some of these businesses that's misusing your social? They're selling your information, your data. Your data is the new, it's like the new it's like the new oil. Data is so important because people use your data to make business. None of your information, your private information, is protected. This is why you got to have certain provisions and understanding trust language that makes life make sense. You don't have it where you have a right to perform an audit. Do that make sense, family?
To me, it do.
Yeah.
Yep.
Yes.
You should have it where certain information can go in the public.
Yeah.
Perfect. You got to understand now, if you commit a crime or something, then that's one thing. But sometimes we're in the public domain too much. Ain't that it, brother Israel? I think that's the last
Yep,
one.
that's it right there. Last slide. Last page.
All right. Questions. Bring them on in.
So you can use a trust to protect your identity, your name, and against someone using your name to, signing your name for anything else, like for fraud or anything.
Yeah. You just got to know how to contract.
Yeah. So this is how you protect yourself against identity fraud then, huh?
You can have something in there that you can have all types of provisions in your trust. Remember, through the state, I talked about right of publicity.
Mm-hmm. Yes. Yeah, let's talk about the right of publicity. I'd like to know more about that.
I told you can protect your image, likeness, your voice, and everything.
Yes.
But if you do it, you can do it on a state and federal level.
Mm. Okay.
So that is where the security agreement comes in, right? Can you hear me? Yeah,
We can hear you.
that's where the security agreement comes in, right? Making up the security agreement.
I'm not getting the question. Related to what? Related to what? The right of publicity or something else?
Yeah, the right of the social security number, all your personal identification information. The name, social security numbers, and anything that has to do with you, your personal identification.
So are you saying use it?
Normally a security agreement, I need y'all to understand. What is a security agreement normally used for? It don't have nothing to do with right of publicity. Right of publicity is a contract. So for example, the actor Jamie Foxx, that's not his real name. That's his movie name. He's under contract. Somebody can own the rights. You can own the rights to that name and doing, you can only do, maybe he said, I can only do acting with any public, other forms of public publicity or any private publicity. This is the only name I can utilize, right, under contract. Security agreements normally is dealing with what? They're not dealing with that. Security agreements is dealing with securities. Securities. Do you know what a security is?
Securing your right to your personal property or your divine rights.
I said a security.
A securities, like a securities, stocks, securities.
Yeah, security.
Oh.
You have unregistered and registered securities. Brother Israel, go to unregistered. Put in Google unregistered security.
Registered security.
Anybody like to read?
That was the remainder. I don't see anything past page 6.
Talking about where it's
Come on the screen. So before securities, like stocks, bonds, and notes can be afforded for sale to the public, they must first be registered with the Securities and Exchange Commission. Any stock that does not have an effective registration statement on file with the SEC is considered unregistered.
Yeah. I was once a registered broker with the NFA and the CFTC.
So you have like stock options, like let's say you form a S Corp, a C Corp, or stuff like that. So I want you to look up unregistered securities. Don't put in that because I really want them to know what is an unregistered security. Say what are
Usually a Ponzi scheme.
unregistered.
You looking for, brother?
I'm trying to say, what is an unregistered security or how? Yeah, click on to this one that says what is an unregistered security and how it works. Do anybody want to read that one?
What is an unregistered security and how does it work?
Yep.
Explore the nuances of unregistered securities, the regulatory landscape and implications for users and investors. Understanding unregistered securities is important for both investors and issuers, as these financial instruments operate outside the typical regulatory framework. They can offer unique investment opportunities, but also come with heightened risks due to their lack of formal registration. The registration of securities is a cornerstone of financial regulation designed to ensure transparency and protect investors. Under the Securities Act of 1933, securities must be registered with the SEC unless an exemption applies. This process involves submitting a detailed prospectus that includes information such as financial statements, management background, and the intended use of proceeds, equipping investors with critical data for decision-making. Registration acts as a safeguard against fraud and misrepresentation. By requiring disclosure, the SEC fosters a level playing field where investors can evaluate the risks and rewards of a security. The SEC's review process also deters companies with questionable practices from participating.
No, hold on right there. Now, somebody said, because you see, it said a security agreement. Now, I'm gonna ask everybody, what is a security? She just read it. Everybody should know what a security is.
It's like a stock, a bond.
Ain't that anything you put your name and number on?
No, she read it.
A registration?
It's a financial instrument.
Yeah, financial instrument. Which could be
It's any
stock.
it's any financial asset that could be bought or sold.
Yeah.
Well, that would be a commodity.
For example, if I got gold and silver, and I got it insured, and I got everything, I will have that before I give it to another trust, and then we will sign a security agreement, securing the asset. It must be an asset. Must be something that you can consider of commercial value. Something that maybe you can borrow, go get a loan and borrow against. Do that make sense?
Yes.
So you will know now that how to use a security agreement. A security agreement is dealing with a security, a financial instrument. In order for a right of publicity to become a commercial viable, commercially, there got to be a contract that gives it value, turn it into some kind of commercial situation or transaction where one party agreed to pay another party a certain amount for the use of it, and now you can have a secure interest in the property through a security agreement, and then you can have that contract insured, right? Giving it now more commercial value where you can leverage it. That's the whole purposes of having a security, so you can leverage it.
Okay, so is that applicable, like, say, in utilities? Because this ties back into, like, my why. I would say it's not that I'm trying to run away from the social. I want to know how to properly use it so I don't mix my private and public affairs. So, for instance, utilities, they ask for a social, right? Your tax number when you're paying utilities. But there are ways to pay utilities, say through an LLC, or what you were talking about, S corp?
I'm trying to get the gist of your question. I mean, because you said a lot. I'm trying to get
Right.
you.
I was asking, is this what you're speaking about now? Is this also applicable to when you have to set up accounts for utilities? Because that is doing business. Like for instance, at where I live, I need utilities. I need water, I need electricity, but these days the utilities, they ask for your social security number. Why is that? That is a form of business, correct?
Yeah.
Okay.
This is what you got to remember. The other party has the right to recheck your contract. Just because you believe that this is a transaction that they're using your name for commercial business, they have the right to not to do business with you either.
Okay, saying that they would be less likely to want to do business if I'm operating in that capacity?
So you first got to put them on notice of what you're doing. So they got to have notice of everything. So you will probably file your UCC, right? And if you're going, so a lot of people, what they do a security agreement with the social, but what they're messing up on is that you got to have some kind of commercial value with it and the use of it. So you have to set it up, file your UCC, right? Non-UCC, then you have to file your UCC 1, and then you got to learn how to leverage that social. But a lot of people don't understand when you put a lien on it, like that's what you're trying to utilize a security agreement to ensure that you secure your rights with that social. And then you can tell them once they utilize the social, the utility company, how, you got to secure interest in that. But where you going to get your rate of return from is you got to have a contract. If you go online, veto their contract, send it back to them.
Hey, could you repeat that? The last thing you said.
Okay, let's say you get a statement. Let's say when you first get your utility contract, how many of y'all do a line veto? A line veto on y'all contracts, sign it, and then write in new terms and send it back. How many of y'all do that?
Not me.
So I want y'all to look, Brother Israel, before we go, look up line item veto in contracts. Most of y'all ain't changing. It was a guy who won his credit card case because he got a credit card and he crossed out the terms, sent it back, wrote in his own terms, sent it back to him, and they accepted it. So
what am I typing in, brother?
Line item veto in contract law. Let's put it line item veto. Definition, look up definition. The power of the president, government, or other electeds to reject individual provisions of a bill. So they saying that, but it's your right to outline or veto the contract. It's called line item veto. So every contract you get, remember, it's a negotiable instrument. You can negotiate the terms. So put in, can you cross out, put in the search bit box, crossing out sections and contracts and up to and negotiating new terms or something like that. Crossing out sections and contracts. You see this, family?
Yeah, some places that have you mark out the part that you don't agree with and then initial it.
Right. And then you can write above it new terms.
Yeah.
And then you can put in there, if they accept it, they have what? So many days to do what? Accept the contract. They don't return the contract void within 3 to 5, let's say 7 business days. The contract got standing. How many of y'all doing that with y'all credit card companies and every other contract y'all get?
Now how do you go about doing that on a digital contract? I can see it on paper when you say mark it out.
You tell them to send you don't want to do it. You tell them you want a hard copy.
Gotcha.
You can't do it on digital. You need a hard copy. Why do you think they want digital? So you can't do that.
Can't do that.
Yeah.
Yeah.
Safeguard.
So you gotta cross it out, initial it.
All right. So,
Okay.
any more questions? If not, I think we've went a little overtime. And
Yeah,
so we good for the day?
yeah, we're good.
I would encourage everyone.
Everybody, I'm gonna ask, is everybody good? I wanna
Yeah.
make sure.
I'm
Okay.
good. I'm good.
Yeah.
I would encourage everyone to look at the class again, 3-4 times if you need to. You know, as much as you need, and write down your questions if you have any questions regarding what you heard this class, last class, whatever. You know, write your questions down and ask. That's what we're here for.
Okay.
All right.
All right.
All right then.
Thank you.
Everyone. Peace, everyone.
Peace, everyone.
Thank you, Brother King. Peace. Thank you.
You're welcome.
Peace.
Thank you, Brother Abdullah.
Respect.
All right.
Thank you.
All right. Peace.
Thank you. All right. See you guys next week.
All right.
All right.